A fundamental principle of company law is that a company registered under the Company Acts is an artificial legal entity, separate and distinct from the members of which it is composed. This principle was endorsed in unequivocal terms by the House of Lords in Salomon v. Salomon. This video will introduce the facts of the case and discuss the decisions of the courts in their socio-economic and political context. It will demonstrate that the approach adopted by the House of Lords was not to lay down any revolutionary principle of law, but merely to give the Company Acts their literal meaning. At the end of the 19th century, the streets of Whitechapel, East London, looked a lot different to the way they do now. It was one of the dirtiest and most poverty-stricken industrial districts of London. Aaron Salomon, a Jewish naturalized Englishman originally from East Prussia, had a small but profitable business as a leather merchant and boot manufacturer. His wife, daughter, and 4 sons were all actively involved in the daily running of the business. Aaron Salomon decided to incorporate his business and make his sons partners. The sons were dissatisfied with their position as servants, and they kept pressing their father to give them a share in the concern. Therefore, Mr. Salomon did what hundreds of others have done under similar circumstances. He turned his business into a limited company. To incorporate, the Victorian Company Acts required at least 7 subscribers to the memorandum. To comply with this provision, Aaron Salomon and 6 family members subscribed to the shares. Every family member got 1 share each, and Mr. Salomon himself subscribed to 20,001 shares. The company was incorporated successfully, and therefore it was covered by the Limited Liability Clause. Limited liability allowed the company to be identified as a distinct legal entity from its owners. However, at the time there was a public mistrust of such companies. According to McQueen, the daily press asserted that England was becoming one vast mass of impersonalities. Nevertheless, Aaron Salomon and Company Limited was now successfully incorporated, and the creditors had full notice that they were no longer dealing with an individual. Not long after incorporating, there was a general downturn in the economy followed by worker protests. Aaron Salomon and Company lost institutional contracts such as those with Army Board. The company had difficulty selling its stock. To keep the company afloat, Mr. Salomon, his wife, and the mortgager Mr. Broderick lent money to the company by means of secured debentures. The company failed to repay the interest to Mr. Broderick. Thus, he initiated a legal action to redeem his money. As a consequence, the company was placed into liquidation. Salomon claimed to be entitled to the remaining assets of the company in priority to the unsecured creditors, on foot of a secured debenture. The liquidator argued that the debentures were invalid because the company was an agent to Mr. Salomon, and therefore Aaron Salomon should be made personally liable for the debts of the company. In the Court of First Instance, Judge Vaughan Williams held that Aaron Salomon used the incorporated company as an agent for himself, ruling that Salomon should have to indemnify the company in respect of its debts to the unsecured creditors. The Court of Appeal upheld the decision of lower court. This time, however, it reasoned that Salomon had abused the privileges of incorporation and limited liability, using other subscribers to the shares as mere puppets, and continued carrying on business as a sole trader. According to Hutchinson and Langlois, these legal proceedings did not impress the business community, and also called into doubt Aaron's original motives for incorporating his family business. In the midst of these legal proceedings, the Shoe and Leather Record Journal in demeaning and anti-Semitic terms, stated that Aaron should cease to engage in financial juggling with a vengeance. Nevertheless, the case reached the House of Lords, where their lordships considered the decision of the Court of Appeal to be indecisive and incorrect, and ruled unanimously in favour of Mr. Aaron Salomon, reversing the appeal.
I am at a loss to understand what is meant by saying that A. Salomon and Company Limited is but an alias for A. Salomon. It is not another name for the same person. The company is, ex hypothesi, a distinct legal persona. If the legislature intended to prohibit something, you ought to know what that something is. All it has said is that one share is sufficient to constitute a shareholder, though the shares may be 100,000 in number. The unsecured creditors had full notice that they were no longer dealing with an individual, and they must have taken to have been cognizant of the memorandum and of the articles of association. A creditor who will not take the trouble to use the means which the statute provides for enabling him to protect himself must bear the consequences of his own negligence.
The House of Lords decision in Salomon v. Salomon is often referred to as a landmark decision. In fact, however, it is simply a literal interpretation of the Limited Liability Act. McQueen suggested that if Salomon was regarded by contemporaries as a landmark, it was largely by reason of its determination of the one-man companies. This decision clarified that incorporation under the Acts was possible not only for the speculative businesses with dispersed ownership, but also for the small family businesses. Furthermore, according to McQueen, the decision of the House of Lords left the legislature off the hook in addressing the nature and the status of private companies under the Companies Acts. The central outcome of this case is that the decision in Salomon is now considered the cornerstone of modern company. And even if an academic, Kant Freund, criticized this decision, he was right to conclude that it changed the economic and social function of limited companies. For better or for worse, the limited liability privilege became readily available to the small businesses at large. And in Ireland, the limited liability company is now the empirically dominant form of corporate organisation. In the words of Rob McQueen, it could be concluded that life without Salomon may now be inconceivable.